The Supreme Court has just issued a chilling denial. Two pivotal cases, U.S. versus Rush and the Robinson Challenge, both seeking to dismantle the National Firearms Act, or NFA, restrictions on short-barreled rifles, or SBRs, have been rejected. This isn't just a setback, it's a profound strategic blow, echoing the High Court's recent refusal to hear challenges against machine gun bans. This decision leaves in place a legal framework that continues to ensnare law-abiding citizens and underscores a dangerous trend of judicial avoidance on fundamental Second Amendment issues. Let's dissect the legal quagmire we're in. The National Firearms Act, enacted in 1934 and later amended by the Gun Control Act of 1968, is a labyrinth designed to regulate certain firearms, including short-barreled rifles. Under Section 922, subsection A, subsection 4 of Title 18, United States Code, it is unlawful for any person to receive or possess any firearm which is not registered to him in the National Firearms Registration and Transfer Record. For an SBR, registration is mandatory. The NFA also imposes a $200 tax on the making and transfer of these firearms, alongside stringent background checks and extensive paperwork, including ATF, Form 1 for making, and ATF, Form 4, for transferring. The core of the Rush Challenge, which the Supreme Court has now refused to hear, originates from an individual charged with possessing an unregistered short-barreled rifle. The Seventh Circuit Court of Appeals, affirming the lower district court, declared SBRs to be dangerous and unusual, and therefore supposedly outside the protections of the Second Amendment. This ruling relied heavily on the 1939 Supreme Court precedent of U.S. versus Miller, a case often misconstrued to justify expansive gun control. The government's argument, astonishingly put forth by the previous administration's Department of Justice, was that the NFA is facially constitutional because it has some valid applications. This is a dangerously broad assertion. Furthermore, they argued this specific case was not the proper vehicle for defining what arms are protected by the Second Amendment, suggesting instead that the Supreme Court should take up a state AR-15 ban to address that foundational question. This position is alarming. The plain text of the Second Amendment, as affirmed in Heller and Bruin, extends prima facie protection to all instruments that constitute bearable arms. Yet, lower courts continue to contort this clear principle, pushing ordinary long arms outside the scope of protection. This judicial gymnastics is a sign that our jurisprudence has taken a dangerously wrong turn, placing arbitrary restrictions on common firearms under the pretense that they are unusually dangerous or especially susceptible to criminal misuse. This rejection means the legal battle to affirm short-barreled rifles as protected arms under the Second Amendment and to challenge the NFA's constitutionality continues to be fought in the trenches of lower courts, burdened by outdated and problematic interpretations. The immediate denial of these cases leaves countless individuals vulnerable to severe legal penalties. Possessing an unregistered short-barreled rifle is a felony offense. A conviction carries a maximum penalty of up to 10 years in federal prison, a fine of up to $10,000, or both. This is not merely a hypothetical risk. It is a clear and present danger for anyone unknowingly or knowingly in possession of an unregistered short-barreled rifle. The case of Mr. Rush vividly illustrates this liability. He was found with an unregistered SBR and faced federal charges. His legal defense, asserting his Second Amendment rights, was denied by the District Court and then the Seventh Circuit, culminating in this Supreme Court rejection. This means the precedent in the Seventh Circuit, affirming that SBRs are dangerous and unusual and outside Second Amendment protection, stands. This creates a patchwork of legal interpretations across the country, where fundamental rights vary based on geography. Furthermore, the NFA's stipulations extend beyond possession. Any transfer or making of an NFA item without prior ATF approval and payment of the $200 tax is also a felony. This encompasses not just commercial transactions, but also private transfers and even the assembly of a short-barreled rifle from a pistol and stock. The potential for inadvertent violations is high, transforming otherwise law-abiding citizens into federal felons overnight. The financial cost of defending against such charges, even if ultimately successful, can lead to personal insolvency, not to mention the irreparable damage to reputation and livelihood. Beyond direct criminal liability, the NFA imposes an immense bureaucratic burden. The requirement for federal registration, a $200 tax stamp, and a thorough background check process for each NFA item creates a chilling effect on the exercise of Second Amendment rights. The ATF's approval process for NFA items is notoriously slow, often taking many months, and sometimes over a year. This delay acts as a de facto restriction, denying individuals timely access to constitutionally protected arms. Consider the complexity of compliance. An individual wishing to lawfully own a short-barreled rifle must first navigate the ATF Form 1 process for making, or the ATF Form 4 process for transferring. This involves submitting fingerprints, photographs, and the $200 tax. For trusts or corporations, additional documentation is required. Any mistake or omission in this intricate process can lead to rejection, further delays, or worse, a felony charge for constructive possession if the item is assembled before approval. This bureaucracy is not merely an inconvenience. It is a financial and time-consuming barrier. The $200 tax, while seemingly minor to some, is a significant financial impediment for many, especially when considering multiple NFA items. Moreover, the NFA also includes stringent requirements for interstate travel with NFA items, necessitating ATF Form 20 notifications, which can be denied, further restricting the lawful movement of registered firearms. This entire system operates as a regulatory overreach, adding layers of complexity and costs that disproportionately impact responsible gun owners. The Supreme Court's denial of review in these short-barreled rifle cases sends a clear, unsettling message. The current court is hesitant to clarify the boundaries of the Second Amendment, particularly when it comes to federal firearms laws like the National Firearms Act. This judicial inaction contributes to a dangerous erosion of constitutional rights. The government's argument, accepted by the Supreme Court through its inaction, that a law can be facially constitutional because it has some valid applications, despite also having unconstitutional ones, is profoundly troubling. This standard effectively allows unconstitutional restrictions to stand, forcing individual citizens to challenge them piecemeal, state by state, and circuit by circuit, rather than receiving a definitive ruling from the nation's highest court. This reluctance to intervene echoes the earlier denial of challenges to the federal machine gun ban. It also stands in stark contrast to other relisted cases concerning state-level AR-15 bans and magazine capacity restrictions. While there might be a silver lining in the court taking up those cases, the immediate dismissal of the NFA challenges suggests a selective approach that prioritizes certain types of Second Amendment issues over others. The government's push for the Supreme Court to take up a state AR-15 ban instead of these NFA challenges is a tactical maneuver to control the narrative and scope of Second Amendment jurisprudence. This strategic avoidance of the NFA issues allows the continued existence of a legal regime that forces law-abiding citizens into a highly regulated, federally monitored system to possess common firearms. The ultimate implication is a gradual chipping away at fundamental rights, where the government's ability to regulate the exercise of those rights expands through legislative action and judicial deference, rather than being curtailed by constitutional principles. This leaves us with an uncertain future for the Second Amendment, subject to the whims of lower courts and the strategic maneuvering of government attorneys. The Supreme Court's denial of review for the short-barreled rifle cases is a stark reminder of the continuous assault on our Second Amendment rights. It is not a final defeat, but a call to action for every responsible firearm owner. The legal battles continue, with other challenges to the NFA, leveraging recent changes, like the $0 tax for certain NFA items, still making their way through the lower courts. Additionally, we must keep a vigilant eye on the relisted rifle and magazine ban cases, which may yet provide the Supreme Court with an opportunity to clarify what arms are truly protected. This fight requires your unwavering support. Engage with constitutional advocacy groups dedicated to defending the Second Amendment. Stay informed. Advocate for your rights. This nation was established by principled thinkers, and it must be preserved by informed and responsible citizens. We must remain vigilant, educated, and united in the defense of freedom. The stakes are too high for anything less.